Assalamualaikum and hi Medha Hartini. My name is Muhammad Nazim, metric number 066382, and today I will be summarizing to you the requirements for a valid marriage. Under the common law, the requirements of a valid marriage are voluntary, monogamous, between male and female, and lastly for life. But under the requirements of marriage under the Law Reform Act 1976, the first one are the age, and also it must be not in prohibited degree of relationship, and consent must be attained from the parents and guardians, and also the consent from between the parties to the marriage themselves. The fourth one is it must be monogamous, and lastly, it must be between male and female biologically. Now I'll be explaining in detail about each requirement. For the first one, age, under the Section 10 of Law Reform Act 1976, the minimum age for marriage is 18 years old for male, while for the female, it is 16 years old. And if the parties under the minimum age, they must attain a license from the chief minister in order to get married. And marriage is void if not complied with according to Section 69 subclause B. The second requirement is that it must be a marriage that are not in prohibited degrees of relationship, which is stated under the Section 11 of Law Reform Act 1976, which it lists the relationships that are prohibited. However, there are an exception made where the chief minister can grant license to marriage under the Section 11 if it is not objectionable under the parties' religion, usage, and customs. For the third requirement, consent, it is categorized into two parts, which are for parents or guardians, and secondly, for the parties to the marriage itself. For the parents or guardians, it is stated under the Section 12 of the LRA 1976 that consent from parent or guardian must be attained for the parties under 21 but above 18 years old to be married. However, consent is not required if the parties has previous marriages before. And for the parties to the marriage, both parties must consent to the marriage themselves, and under the Section 37, it is an offense to compel a person of 21 years old to marriage or preventing them from marrying another. The fourth requirement is that the marriage must be monogamous. Under the Section 5, the marriages under the LRA 1976 were monogamous, and non-compliance will result in criminal offense as according to Section 7, and also under the Section 494 of Penal Code, anyone who don't comply with this shall be imprisoned for 7 years and fines. For example, in the case of public prosecutor against Rajapan, the respondent was married according to Hindu custom in India in 1947 with the complainant Pelaniamal, and later on in 1954 migrated to Malaysia. But in 1984, he went back to India and married a girl named Saraswati and brought her back to Malaysia. The respondent was charged for an offense under the Section 494 of the Penal Code. The last but not least, the fifth requirement is that a marriage must be between a male and female biologically. According to Height and Height, marriage is defined as a voluntary union of a man and a woman to the exclusion of all others. This means that anyone who changed their gender through sex change surgery cannot be married under the Law Reform Act 1976. In conclusion, for a marriage to be valid, it must meet all the 5 requirements, as any vitiating factors can lead the marriage to be void. That will be all from me. Thank you.